All right, just doing a technology sound check. I'm going to get a heads up from my team that both the video and audio are coming through clean. Okay, we're waiting for a few registrants. Just give it maybe another minute. And it's 2 o'clock. Thank you for joining the webinar regarding qualified settlement funds. First off, the qualified settlement funds will not save you from the coronavirus. I imagine all of you are working at home and sequestered, but this topic is very prevalent this last few weeks with many of the courts being closed. So we wanted to jump in and give all of you practitioners, experts in the field and people in civil justice, not just a primer, but some deep dive on best practices that we think you can incorporate every single day, every year, best for your practice. So whether you're focused exclusively on mass torts, I imagine many of you, more likely or not, are your sole proprietors or managing small law firms, that the use and integration of the qualified settlement fund technique and legal tool and escrow is paramount in your practice year in and year out. Something to think about. Next. So one of the things that kind of keeps coming up in topic is, what is it about the attorney trust account or IOLTA account that doesn't get the job done? And the practice of litigation has changed substantially in the last decade or two. And so we think that the qualified settlement fund has matured to the point that it can, in most cases, certainly significant cases, replace, from a conceptual perspective, the IOLTA account or attorney trust account. Next. So without a QSF or without a qualified settlement fund, you really are not able to separate the natural business interests between attorney and client. And if you're resolving an individual PI case or some type of individual tort, that you really have to have the entire plan in place in order to execute releases. And from that perspective, it's very cumbersome because a lot of things are very difficult. You take into consideration liens or Medicare's interests, etc. And so a qualified settlement fund really solves that. Next. There are a host of benefits to relying on a qualified settlement fund in any one particular case, not necessarily in order. The biggest one is time, time to plan. The end of litigation can be very complex. So, just as I like to say, if depositions are preparation for trial, then qualified settlement funds are preparation for settlement. Good fundamental takeaway. Time value of money. There's obviously interest float, earnings on any deposit. And so you think about who that inures a benefit to. It can pay for, our administrative firm. It can pay for lien negotiators, special masters. And so by making money on the deposits, you've got a little bit powder to go around. It also, creates obviously benefits for both the client as well as the attorney. And those two functions are separate. It absolutely, in all cases, eliminates the defendant's involvement. And if you're in a mass tort and there's a significant inventory settlement, those multinational defendants may still want some signing off authority, etc. But for the most part, the planning and the downstream distribution from a qualified settlement fund really shouldn't involve a defendant or their counsel, and allows either plaintiff steering or plaintiff or your signatories in your firm, to manage that distribution day to day, week to week. Next. It's important to recognize that you have to negotiate payment and resolution of a lawsuit, a tort, or an inventory of cases into a qualified settlement fund. Seems pretty basic, but we get a lot of our newer clients that haven't established a qualified settlement fund before assume that they can just, send a general release for the case and also still create a qualified settlement fund. It really should be negotiated, something that you should have a material term in your case with defense counsel that you're resolving it, and they have agreed as part of the agreement to settle to pay to who you direct them to. Your discretion, whether you disclose that that's going to be a qualified settlement fund or not. Your biggest problem defendants are insurers, are really the Department of Justice and AIG. There are others. I really do think that qualified settlement funds are misunderstood by the defense trial bar, and if they don't know what it is, they're not going to agree to it. I mean, so do yourself a favor and make sure that you have it as a material term. Your agreement should include payment to the qualified settlement fund and its terms. We, of course, if we're the administrator, then we're providing the W-9 and all the tax ramifications necessary for release of the defendants for payment. The payment of the entire settlement by regulation should be payable to the qualified settlement fund. You can't really split it. You pick off, portions of a particular settlement, so long as the contribution by one defendant extinguishes that defendant's liability. It's a proper payment. You can pick and choose if you have multiple defendants in a particular case, and you're getting angst or some difficulty with one or two of them. You certainly can pick off one particular defendant to fund the qualified settlement fund and let the balance or the other defendants or follow-on settlements pay in cash. If for cases that require court approval, you're obviously, if the courts are not open, you're not getting that resolved. I'm going to get into the type of qualified settlement funds that we can create and establish, and some of the decision making the trial lawyers face on a day-to-day basis with regard to those. But if your underlying case, if you have a minor or a confident or it's an estate, that process still has to occur, of course, or obviously, but that if you plan ahead, you at least can have your qualified settlement fund established and approved in the manner that you choose in advance, of that. But obviously, money is not going to move in any one particular case if it does require court approval. So talking about the types, all qualified settlement funds are, court ordered, and get into the specificity around the different types. And fundamentally, they are an escrow account in accordance with the Treasury regs. So at a number of different levels, you have a decision tree between, what type of case is it? It has to meet claim type in order for it to be a qualified settlement fund. So most of your torts, your mass torts, your breach of contract, and that are going to be types of cases that can be paid or settled into a qualified settlement fund. Ones that you, for the most part, can, or breach of contract, whistleblower, qui tam, those type of cases. So all individual torts, all mass torts, especially your personal injury type, are qualifying. So the types of QSFs that are out there, we manage and operate a national qualified settlement fund, and we got the order on that back in 2017, and it's a standing national master qualified settlement fund that all law firms throughout the country, if they have a tort or tort type right case, can adjoin to. And so the big advantage is that, especially now with a lot of courts being closed, if you try to settle a case and you do want to avail yourself of a qualified settlement fund, that we already have that court order, and you're able to adjoin to that master QSF nationally without an additional court order. We have to have an escrow agreement and services and that you can entail. There is a firm, what I call a firm level qualified settlement fund. So you got the Mary Jones law firm, in Iowa, and she's managing 20 or 30 cases in resolution per year. Any lawyer, law firm, managing partner can create a qualified settlement fund for the specific scope of their entire inventory. And so a single court order establishes a qualified settlement fund for the entire firm and all of its cases. And then as a law firm may resolve cases, whether they be individual cases or inventory settlements, that can be paid into that particular, Mary Jones Law Firm qualified settlement fund, and the arrangement of that is very straightforward. Your choice in terms of jurisdiction is wide open. If you look at the Treasury regs, I'm happy to circulate around. The regs really say that so long as the order that is entered to create the qualified settlement fund is done, you can have a county clerk order. It can be a sub-entity of the government. Any court, which include your property courts, your circuit courts, your trial courts, including your federal courts. So any court in the country, can create this. And I think there's ambiguity, or at least certainly there's no clarity on what court may be appropriate. I think a lot of trial lawyers assume that if they're indexed in their trial court in XYZ state, that they have to go to that particular court. And you obviously have some notice issues with defendants if you're filing. So we prefer, in most instances, if we're getting qualified settlement funds set up in advance, either for the firm or for individual cases, that we do that in courts that don't require notice and fundamentally are sealed. Our preference, when we're the administrator, we're here in New York, our circuit court, all files and petitions, are naturally and automatically sealed. So there's confidentiality. So confidentiality being an issue when you're filing, whether it's in advance or if a case has resolved, that's a material point. And then you obviously have all of your individually ordered QSFs. And so it could be an inventory of 20 or 30 cases, and that you get a court order establishing a fund just for those cases. And so it's like a single purpose qualified settlement fund, or very specifically, it's just for an individual case or wrongful death, in which case the payments for that individual settlement trigger the defendant's releases and allow administration of the settlement funds, for that particular case. And then fundamentally, that qualified settlement fund would end and be closed appropriately, based on the fact that there's no follow-on settlements or inventory, et cetera. Next. So a little background on a National Master Qualified Settlement Fund. It's obviously the framework for this allows for the interpretation of the IRC and the Treasury regulations for qualified settlement funds, specifically set forth a framework that cases can be settled into a fund, so long as it meets the criteria. So our use of our National Master, we use a joiner agreement that the managing attorney signs, establishes signatory authority, establishes the escrow and custody, and all of the arrangements there. So if anybody wants to see our draft, a joiner, and the scope of services for utilization of the National Master, it's available. Just email us. The real benefit to qualified settlement funds, regardless of whether it's at this level or any other, is you should be able to, with significant settlements, enter into this service arrangement with an administrator for really no cost. Although interest rates are much lower, and a lot of administrators are addressing what their fee rates and schedules are, more than likely or not, as long as interest rates are above 1%, or you're able to get into a money market account of some kind that earns 1% on the money, there'll be enough fee for whoever your administrator is. Next. So for firm level qualified settlement funds, you establish a single order, scope of services, and the same escrow agreement signed by the firm administrator or managing attorney by signature line. But then all of that firm's cases can be settled into that particular qualified settlement fund. That has a tremendous advantage for ease of use and not having to go back to court to get a court order on every single case. You, of course, can, if you so choose, you just really don't have a need for an ongoing maintenance and management of a firm level qualified settlement fund. You can set one up on an individual case, and we do that all the time. You tend to incur a little bit of cost or fee if the interest deposits are going to be very brief. for these types of cases, but they're really useful in estate cases throughout the country. It allows you to resolve the case, have the defendant pay, and it has nothing to do with whether multiple claims or not. Next. So our holding company, Seventh Amendment Holdings, is the company that we use to serve as administrator. It's a domestic LLC in New York. We've been at this for a long time. We've been involved in landmark cases, 9/11 and BP, Deepwater Horizon spill, the Bair bombing, etc. So we have a tremendous amount of experience. We've probably managed a few $1 billion in settlement distribution, and we really handle it all. So that regardless of the type of case, whether they be inventory of sex abuse cases or just individual car wreck cases, they all can conform. They just should be fundamentally a benefit either to the lawyer or the client, preferably both. Next. So what to expect from your fund administrator? If you have never done a qualified settlement fund before, then you're dealing with a private banker type of relationship. You obviously have accounting protocols, you have security and custody you need to make sure that you're aware of. It's really no different than the level of scrutiny that you do provide over your IOLTA or trust account. It's just once removed, and the real critical nature of that is you haven't received any of the revenue from the fee yet. But your fund administrator should be uber transparent. You should be able to get daily reports on accounting and distributions, interest crediting, and a specific direct custodial statement from wherever the assets are custodied. And setting up those protocols in advance are very, very wise. It allows fundamentally for your staff, your legal staff, to not be as much in the weeds on specific distribution. So if you've hired a lien negotiator or a resolution firm, then all of the lien payments, by definition, operate and are distributed by the qualified settlement fund administrator direct to the lien payees. There's a record of that and accounting and reporting back. So that coordination of distribution, both to the clients as well as lien holders and other payees, to include co-counsel, is all done on signatory authority on your letterhead, direct to the QSF administrator. So you maintain control of all distributions, or should. There's obviously a lot of interface between the law firm and their client. We take the position that we don't believe, because it's a litigation tool, that attorneys need their client's consent in order to establish a qualified settlement fund, because they're resolving the case just like they wouldn't need their consent to use their IOLTA account. That's not a legal opinion. If people want some backup on that, I'm happy to provide the research. But fundamentally because it's exercising the lawyer's judgment and discretion, just like hiring an expert in the course of litigation. Now, most of our clients do disclose, and they say, we're going to involve a third-party expert, settlement administrator. Here's what they're going to do. Here's how they're getting paid. It's all about board, etc. And they integrate that into their settlement distribution statement. There's a lot of benefit in having a QSF administrator involved, certainly in more complex cases, because of all of the collaboration that happens with other third parties, lien resolution specialists, special masters, and other important vendors on distribution. Really sets up the dynamic for you to professionally distribute. May seem like overkill on a single case, and sometimes it can be, but I'll get to some of the tax benefits in that are available on single event cases. And then to perform all activities related to the banking and depository relationship that's necessary for distribution, closeout, and filing the tax returns, the fiduciary tax returns for the QSF. Next. You may not be able to see, the exact timeline. I'm happy to email it around to our registrants, but fundamentally there's a timeline. Just like you're preparing for settlement, we think you want to make hay while the sun shines. Get your ducks in a row and do your planning ahead of time. If the case or inventory really calls for the use of a QSF, you want to start that process early, obviously. Now, every single day of the week, people call us and they've resolved a case and want to avail themselves of the use of a QSF. You can always do it after the fact. Sometimes it can, become a fire drill, which you can of course avoid, but there's no problem with whether it's before or after. Some people would prefer that it be after, and they have the discussions regarding resolution and settlement and the disclosure of the use of a qualified settlement fund. But our preference is prior to settlement, getting the court order or establishing the adjoiner agreement to join the master. Defendants pay the gross settlement by wire, preferably. I know a lot of our counsel asks us all the time for, distribution and payment instructions. Defendants and defense counsel are notorious for, even though they've been directed and even though they agreed in advance, hopefully, they'll still put the client's name, or they'll make the check payable to the law firm and the client and the settlement fund. So there are real payee challenges associated with checks in a lot of insurance companies, or TPAs. That's the only way that they do distribution on claim resolution. So you got to get that in writing in advance. You're going to have some problems if you really want to rely on qualified settlement fund, because there's really nothing a qualified settlement fund administrator can do with a check if it's triple party or double party. Banks these days with the fraud provisions and anti-money laundering just don't allow for third party assignments. They can't verify the identity of the signator. So wires are preferable because then it's like titling. Obviously, the fund administrators coordinate distribution, both to the law firm as well as to any signed distribution instructions and payees. So it makes it super simple. ACH or wire is our preference. All the tax documentation is handled by your QSF administrator. All 1089s for the law firms that have taken distribution in any one particular year. If the underlying case, the tort itself is taxable, then the plaintiffs themselves will be 1099, both for interest as well as for the principal that's distributed to them in a year. They obviously have the QSF administrator manages all monthly financial accounting that's prepared for your firm. Once all distributions are made, then we move into the process of shutting the qualified settlement fund down. So if there's $1 on deposit January 1st, that fund is still open in the following year. And so we do a good job of, if there's not really any follow-on settlements, that in December you want to be able to zero out the balance in those QSFs so that there's not then again another accounting fee. Next. So let's talk about the clients for a few minutes. Obviously, if you can take and settle a case into your escrow account and pay the client, no harm, no foul, great. Obviously, don't use the tool. Don't incur the additional time and expense and coordination if there's no value. And that may be a fairly significant amount of cases. But if you start focusing on what the real benefits and value to a qualified settlement fund is to your client, you more than likely will be encouraged to rely on the resolution technique a bit more frequently. So the biggest benefit to your clients is time. I was just on an hour-long call this morning with a family in North Carolina, a young couple in their late 20s with a kid with cerebral palsy. And whether that case settled or resolved into a qualified settlement fund or not, that client, that family, that couple, they need time. They need time to figure out what firm to create the special needs trust, who to rely on as an expert in the settlement planning process, whether or not to avail themselves of a tax exemption of some kind. And so what's unique about the business relationship between trial lawyers and their clients is that they're married at the hip during litigation. But once the case resolves, then those business interests diverge significantly. And for more than a decade, I've had many good friends, clients, and trial attorneys who I just met represent that they resolve a case and they want to collect the cash. It's like modus operandi in terms of collection, but that has some consequences for the clients. If they back in the day when people were doing a lot of structured settlements, which people are not doing any of these days, or very few, then it was the tax benefits fundamentally that were, driving the planning and the qualified use of the qualified sum fund. But now it's really fundamentally what, do they need time to figure out what type of trust? Are they moving? Does their, disabled loved one, have any type of government benefit that they want to preserve? And so taking the time to do all that planning, it might be a month or 2 or 3 at most. It separates that business interest, and the law firm wants to collect and take their fee, assuming that their state bar rules allow. They can take their fee as soon as the defendants pay into the qualified summons fund, leaving all of the time and time value of money for the clients. Next. So I just talked about special needs trusts, domestic asset protection trusts. Where should they go for wealth management? We uniquely in our firm offer a complete tax-exempt periodic payment, which allows for for any plaintiff or family to have a tax exemption on earnings. You can't do that without a qualified summons fund, and so whether that's valuable or not, you want to figure that out in advance. But having a lifetime exemption on earnings, whether it be interest or dividends or capital gains, that's a real value to families, especially if they're having to settle for what more than likely is a little less than they would have wanted ultimately long term. So all the machine of litigation, that tax exemption is still valuable, and in order to preserve it, you do need either a qualified summons fund or a friendly needed defendant to do an assignment. Next. Biggest benefit to attorneys. I'd say this every single day on the phone. That's why we're doing this webinar. It's your ability to manage your annual revenue. If you're settling a case in March and it's a significant case for your firm, it's a good thing that you're able to get that case resolved, but your business interests, your bottom line, or if you're doing distribution in terms of your compensation structure to the rest of your firm, you may not want all of that money in 2020. And so a qualified summons fund uniquely gives you the ability to plan year over year. Second, it preserves your right, next, to do what is called a deferred attorney fee, which we do all the time. You want to separate the concepts, though. Just because you've done a qualified summons fund does not mean that you've deferred your fee in what's considered to be an attorney fee deferral. They're two separate things. You can't get one without the other. But if you just set up a qualified summons fund on a case or for an inventory of cases for your clients, and you've not made any decisions, you can collect your fee straight away, or you can wait till the first quarter of 2021 if that makes sense for you from a revenue perspective. So additional benefits to you in terms of being able to. Most attorneys don't at the end of the year or during the year, really know what their tax position is going to be. And so one of the big benefits of having some fee accumulate into a qualified summons fund during the year with multiple cases is that you're going to know what kind of year you've had. And so we have a lot of QSFs on file where law firms will settle 3 or 4 of their bigger cases into the QSF, and as they get closer into the 3rd and 4th quarter, they really start to see how good the year has been, or if it's been a little lean, they take distribution of those fees by signature authority on the letterhead of the QSF administrator. That allows them to collect those fees and recognize that revenue in 2020. So that's critical, and that's a game changer in my opinion for so many attorneys throughout the country that if they're resolving a big case in the early part of the year, they're probably already thinking, do I want all of that this year? And without the QSF, they have to make that deferral decision in the context of the release with the defendant. So that is not a preferable way of deferring your revenue and creating a tax deferral for yourself as a business owner or managing attorney. As part of our attorney fee deferral, just to talk about it for a second, for 20 years, I've talked to lawyers and they assume that if they're going to do a fee deferral, then it has to be an annuity. And that is not the case. It can be backed by investments. We have a revenue procedure ruling from 2003 that says that, you know, if you create a proper periodic payment, that it can be backed by investments. So that is black and white. It's going on, you know, 18 years, you know, of precedence. So you should think of the ability to do a fee deferral as an unlimited 401k or profit sharing plan, and not getting into the specifics on the advantages or that. There's no limit. You can defer $1 million in a year with an attorney fee deferral. And so the QSF really relieves the defendant of their angst and you maybe making good money as a trial lawyer. And so that's why we like qualified settlement funds if our attorney clients are preferring to consider at least a fee deferral, but they just don't know whether they're ready to make that decision yet. It could be because they're busy in trial and they don't have time to make the decision to focus on it, because it is a complex financial evaluation and decision making. And the attorneys that we work with need time to do that. They consult with their spouse or significant others, look at their holdings generally that are taxable, evaluate where the markets are, you know, et cetera. So, you know, biggest takeaway there is if you did an attorney fee deferral, you could do your entire fee and you could have it all paid back to your firm next year, and you could have it parked in treasuries or something very safe like money market in that. So you're not necessarily making a big investment decision, but you're controlling your timing, and that timing is critical year over year. Next. So that leads us to our question. Give me just 1 second, see if we have any. We're right at 2:30. We haven't had any questions come in. I'll leave it open just for a few more minutes in case anyone is evaluating, you know, what we've just presented. I will say that, like some of the frequently asked questions that, you know, that we get is like, where do we custody? We custody either as Schwab or BB&T. You want to do an evaluation of your custodian, and that's not your firm administrator. You want to make sure that your law firm's assets and settlement are parked and safe at a custodian that you trust. And we do a lot of due diligence and work regarding the balance sheet and safety and security of the institution that's going to custody the assets in context with whether or not you want to be on balance sheet. So, for example, BB&T or Truist now, their name. And we're agnostic. We'll work with any bank. We've worked with M&T, with Citibank, with Esquire. There's a lot of good custodians out there that QSF administrators can rely on. But you want to understand that balance sheet risk. And so we, for the most part, highly recommend government agency money marked with a solid NAV for safety of principle. And that's a good takeaway. Another question I get a lot of times is, as well, and this will probably be the last FAQ, and we'll bring it to a close unless a question comes in, it's just how do you make the decision on jurisdiction? Because the regs are so, you know, loose. And we had a very significant case with a very prominent trial lawyer in Colorado earlier this year, and they get involved with a probate law firm that then who had never established or tried to create a qualified settlement fund with the probate courts in Colorado, and that didn't go well because you always have the issue of having to kind of train your law clerks and your judicial officers on what it is that you're petitioning for, et cetera. I mean, so you do have choice around that, but like all decisions, those decisions have ramifications. I mean, if you're in an MDL or you're in a federal court, and you know the sophistication of the bench in those types of cases makes it very easy to petition and get your approval. But it's not that cut and dry in all cases. I mean, so you do want to put some time in advance in speaking with a potential qualified settlement fund administrator about where they're going to petition, where you're going to get your order, et cetera. So, well, with that, we did have one question come in. How do you obtain a qualified settlement fund? Well, again, it's by court order. all QSFs are established pursuant to an order of a court or proper, authority of the government. And so in order to have the benefits of a qualified sum fund, has to first be created. It's its own entity. It's like a corporation or a trust, has its own tax ID, and is created pursuant, to that order of the court. So answering that question that we had come in. And with that, I hope everybody is staying safe and not getting what they call Zoom bombed as we all work from home and remotely. These are tough times. And so thank you for spending a few minutes with us today. If anybody's interested in the link to the recording, we're happy to share it all out there. With that, bring it to a close, and best of luck out there. Everybody stay safe. Thank you.